I know you're out there. I can feel you now. I know that you're afraid. You're afraid of us. You're afraid of change. I don't know the future. I didn't come here to tell you how this is going to end. I came here to tell you how it's going to begin. I'm going to hang up this phone, and then I'm going to show these people what you don't want them to see. I'm going to show them a world without you. A world without rules and controls, without borders or boundaries. A world where anything is possible. Where we go from there, it's a choice I leave to you.
The only people who don't want to disclose the truth are people with something to hide. The only people who don't want to disclose the truth are people with something to hide.
And the agency is not notified of that decision until they actually get the written decision. But because of the time frame involved here, and this is not unique to this case, it's gone on past with other cases, and it's going on with all of the other challenges that are being heard to various petitions today. The Secretary of State has requested that they be orally advised of the judge's decision as soon as the judge makes up his or her mind, and then the judge has to issue a written decision no later than 10 o'clock tomorrow morning. So I am not, under the circumstances, since I do want to review the election laws that councils have referred to, at least with regard to that issue, if not the other issue, I do not expect I'm going to give you a ruling from the bench as soon as this hearing ends. I will be issuing a ruling, again, my deadline is 10 o'clock tomorrow morning. If I, for some reason, conclude I can't actually decide this until I put my pen for the signature on the document, it will be decided by 10 tomorrow morning. It's quite possible that I will make a decision sooner than I actually am ready to write the, put the signature on. And the Secretary of State will be advised at that time, and counsel, I believe counsel will be advised at that time as well, although I have to make sure about that. But I do want to warn everybody that given the fact that I do want to study a couple of these, take a look at some of these statutes more closely that have been raised this morning that I know were not actually in the petition, that argument. I am not expecting that as soon as counsel finish their arguments here that I'm going to give you a ruling from the bench. So, with that said, I am not going to dismiss the case at this point. So what I want to hear now, do you have any evidence you're going to produce, Michelle? No. So what I want to hear now is I want to hear argument. And let's, for the moment, let's talk about, we know what the arguments are, I think, generally with regard to the birth certificate issue. Let's talk about the natural born citizen issue, which is a legal issue. That has nothing to do with the evidence here. As I said, we can take this in the context of the fact that it is a well-known fact, certainly nothing that the President would deny, his campaign would deny, that his father was not born in the United States, and his father was never a citizen of the United States. Now, with that context, counsel, Mr. Apuzzo, you have already discussed partly, I would say partly, you've already mentioned some of the position that you've raised, and you've argued it extensively in your brief. And you've mentioned a couple of United States Supreme Court cases coming to us from back in the 1800s that deal with this issue in one form or another, because I think it's fair to say that, to my knowledge, there has never been a direct ruling in the context of a presidential campaign or such on the issue of natural born citizen. It could have come up, I gather, having learned interestingly in the Chester A. Arthur case, but it was not ruled on in that matter because they had another issue about whether he was born in Canada. So the issue of what natural born citizen, I gather that was not actually ever ruled on. So there is no decision that I'm aware of, and I don't think either, of course, Ms. Hill hasn't filed anything. Is there now there have been decisions in the context of this, I understand, in the context of Mr. Obama, but before that, before the Obama controversy. The issue has come up before. It came up with regard to George Romney, who was actually born in Mexico, and there was some, which I actually don't recall the exact detail of why it was concluded that he was legally allowed to run, not Mitt Romney, but George Romney, his father. And it's come up, of course, with Senator McCain because he was born in the Canal Zone, or his father was military. But in the context that's come up here, where it's not a child of a military person and it wasn't the unique circumstance that involved the the Mormons, I think, in terms of why certain Mormons were in Mexico, which I think is why Mr. Romney was allowed, although I haven't looked at that. This issue has not been decided prior to the Obama issue by any court that I know of, certainly not by the Supreme Court of the United States. So with that said, we have some case law that is discussed in other contexts, have discussed the issue of common law, non-common law, and so forth. Is there more you want to add to your argument, Mr. Apuzzo, than you said earlier in the discussion today and what you said in your brief before I hear from Mr. and before I address counsel?
Yeah, well, I would just like to highlight that we have to go, first of all, if we're going to understand what the natural born citizen clause means, we can't just look to a case in 1898, Juan Kimart, and say, oh, here's what it says, oh, therefore that person was ruled a natural born citizen, which the holding does not say that. It doesn't say he's a natural born citizen, it says he's a citizen. Okay? But the point there is that
he didn't have to be a natural born citizen.
He didn't have to be, exactly. Yeah, I've said that time and time again.
But, well, go ahead, because I don't want to get into it. I have some questions I want to raise, but I want to let Ms. Hill give her argument before I do it. So, right.
Yeah, so clearly all he had to be was a citizen, so he wasn't getting deported from the country, which is the standard today also. If you're a citizen, doesn't matter how, naturalized, derivative, acquired citizenship, born a citizen, there's all kinds of different citizens, how you can become a citizen. And all those situations where you're a citizen, they're all born with some kind of alienage, either because they're not born on the soil, or because they're born to one or two alien parents. Now, of course, if you're born outside the country to aliens, you have to naturalize after birth. Okay? But if you're born either here or abroad to at least one citizen parent, you could be a born citizen of the United States, but you're still naturalized because you have alienage when you're born, either because you were born on foreign soil or because you were born to an alien parent. And the reason with the alien parent is because of jus sanguinis, which goes back to time immemorial, inheriting citizenship and allegiance from parents. And jus soli, acquiring citizenship and allegiance from the soil. Okay, so either one of those can give you alienage, either one. Now, Your Honor mentioned McCain. Now, here's a perfect example. There's an exception. If you're born abroad and you're in the military, your parents, what does the common law say about that? Well, again, why do I say common law? Because that same common law tells us what a natural born citizen is, which would include McCain. But let's not get off on this tangent with McCain. But the reason why I mention McCain is because it's the law that applies to tell us if someone is a natural born citizen. So when you go back to the founding members, they look to the natural law and the law of nations for a tremendous amount of law that they were dealing with, because they couldn't use the English common law anymore. Because it was well, because they just overthrew the British control. They just overthrew because first of all, the English common law was for the monarchy. Okay, and there's a lot of historical evidence that with Madison, he even writes a letter. Says we could, we went at the convention, we couldn't adopt the English common law. How are we going to adopt the English common law? What, we're going to bring all this monarchy and all these things that we broke away from. We're going to bring it over here again. Yeah. I mean, that's not cited in my brief because there's a ton of other information that's not in the brief. That's just an objection. But the point is that the common law, the English common law, was allowed to continue on the state level. Okay, and that's not in dispute. Torts, marriage, criminal procedure, contracts, inheritance, on and on it goes, because we had to maintain a society. We had to maintain it. We didn't revert to a state of nature. We had to maintain order. So we continued under the English common law on the state level, but not on the national level. The Constitution in Article 3 tells us the laws of the United States. What are the laws of the United States? Now, not state law. United States. Well, it was the Constitution, it was treaties, acts of Congress, and the law of nations. And there's plenty of...
Have you read Juan Mark?
Yes, Juan Mark, yes.
Let me hear what you have to say about Juan Kim Ark before I hear counsel.
Yeah, well, Juan Kim Ark, what happens there is that we have a new type of citizenship that the court is looking at. Never been decided before. A child born in the United States to alien parents. So what the court does is, and the court actually did it for policy reasons. Okay?
Now, that's what they did for policy reasons. I want to know what they said in the decision.
Yeah, what they said was that a child born in the United States to domicile alien parents is considered born subject to...
Is that what they actually said, that they had to domicile alien parents?
Yes,
Where in that decision does it say that?
It's right in the holding. I mean, I don't have it right in front of me here, but it's stated more than once.
Okay.
Domicile is very important, Your Honor. It replaced citizenship. That's how important it is. See, the United States became a nation that looked at domicile in order to make you a citizen. That's what happened with Juan. Because before that, your parents had to be citizens. And the statutes of Congress started in 1790, then 1795, then 1802, then 1855. These are all...
You mentioned those. You didn't explain what your reference was to them. What in those statutes is relevant to the question before me?
It proves that Mr. Obama cannot be a natural born citizen.
How does it prove?
It proves it.
What does it say?
Very easy.
What does it say?
It proves it by exclusion. Because the statute says that you have people who become naturalized. Okay? Now, a naturalized person is somebody who's not born here. Okay? Once that person naturalizes, his children or her children can become American citizens.
Okay.
Okay?
That's not the situation.
Oh, right. Well, yeah, that's what, exactly, Your Honor. See,
So
if
how
this
does that
happens,
speak to this situation?
well, very easy. If this happened, what we have happening today, if this happened in 1790,
This isn't 1790.
no, but I'm answering Your Honor's question. Okay? If this happened in 1790, Mr. Obama would be a natural-born British subject. He would not be a U.S. citizen because his father never naturalized. And back then, the wife automatically took on the citizenship of the parent, automatically. You have British statutes on the books that said if you're born out of the dominions to a natural-born British subject, you're a British subject for life. Okay? So the British Nationality Acts that existed then,
Right.
They-
His father a British citizen.
his father was British.
It's got to
His
do
son,
with, what does that have to do with Mr. Obama?
well, a lot, Your Honor. We're talking about what
On the assumption, because remember, of course, we understand that this whole argument, a natural born, is based, we put this in the context, is based on a conclusion, because otherwise it's not relevant, that he actually was born in the United States. So we're assuming for the purpose of this argument
Yes.
that Mr. Obama was born in the United
Yes,
States.
Your Honor.
Right.
Yes. But the point is, it's not sufficient. There's even an article in an old newspaper written by Publius, okay, which probably was Madison, because the three of them were Publius, but because of the age of it, and it says clearly right there that the individual was born in America. He was born in America. And I could provide this to Your Honor, if I can even fax it this afternoon sometime, but the individual was born in America, and the argument was, oh, he's born in America, he's a citizen. And Publius said, no, we don't have such a law. If you're born in America, that's not sufficient. Your parents got to be citizens. This was Madison. In an old newspaper, this is a very valuable find, which that particular article went to the statute of 1802, because that's what was being argued at that point, which is the same as 1790 and 1795 on the language that I just cited. That in other words,
This position in your argument been accepted in any court in regard to this argument concerning, and Ms. Hill, I don't want to jump into arguments, I'm not sure, but I want to ask counsel.
Yes.
Because you're making the argument. The argument has been made that Mr. Obama is not a natural born citizen. And I am by far not the first judge in this country to be presented with this argument, correct?
That's correct, Your Honor.
Has any court at all, appellate, federal, state, administrative, any court at all accepted the argument that he is not a natural born citizen?
Okay. I can speak about the cases that I've been involved in.
Well, I assume you, well, all right, well, let's take the cases you've been involved in.
Yeah, I was involved in the Kirchner versus Obama Congress case, which went to the U.S. Supreme Court. It was denied cert. The case was dismissed on standing. And the court in the Third Circuit said, we cannot decide whether the American common law definition of a natural-born citizen is still continuous.
When they said it was decided, the case was dismissed for standing. So
Right,
they never got to
exactly.
decide.
That's exactly right.
So the answer is that they didn't rule.
No, they did not rule, but
That's a different. I asked you if any court has accepted your position. I understand that some courts on standing haven't chosen to even discuss it, but we're not talking about that. I'm asking you, is there a court that has ruled on the issue, on the merits of the issue, that has accepted your position that he is not a natural-born citizen?
No, but the case law as it exists shows what a natural-born citizen is.
So in other words, every court, and you're entitled to your opinion, I understand that, but every court that has ruled on the merits on the issue, state, federal, administrative, every court that has rejected this, misread the law, misunderstood the law, misunderstood the United States Supreme Court discussions that have gone through this issue, at least in terms of extensively referring to natural born. They were all...
Well, Your Honor, first of all, a lot of them were procedural. It's like my understanding.
Counsel, with all due respect, counsel,
Yeah.
I didn't ask you about standing. I know there were cases that were dismissed for standing. In those cases, there were no merits.
Right.
I'm asking you on the merits, is there a single court that has accepted this? And you told me no.
No, there is a case in Indiana which actually said that all you have to be is born in America. It doesn't matter what your circumstances are. But now that case did not rule that Mr. Obama was a natural-born citizen or that he was born in America.
No, well, we're not talking about whether he was
Yeah.
in America, because that issue I understand. He wasn't born in
Yeah.
America. We don't have to talk about natural born.
Well,
We're
because
talking about now the second portion of the case. If you win the first portion of the case, we're going to get there.
yes. The point is that any case that has dealt with this issue, there's a federal case called Tisdale in the Fourth Circuit.
Right.
Okay, and Judge Gibney said that. Now, he cites Hollander for the proposition what a natural-born citizen is, and Hollander was a standing case. But be that as it may, there are some cases also down in, I think Georgia might have touched it.
Judge Milley?
Yes, I think he does say that.
He does?
Yeah, I'm pretty sure that he.
Yes, I have Judge Milley's decision right here.
Yes.
I happen to know Judge Milley.
Oh, yes.
He did discuss this at some, and he referred to the Indiana decision.
Yes, that's what I guess.
And he didn't accept your position, did he?
No, it doesn't mean that I'm incorrect.
Okay. Your opinion.
What it means, why? Because first of all,
I'm asking you if there's a legal authority court that has accepted this position.
Okay.
You're advocating. Because this position has been argued, well, there have been standing cases and so forth, so I haven't counted how many times, but there are certainly, I suspect, dozens, I think, that around the country where the issue has been raised.
Oh, no, raised, like
Raised.
100, I guess.
Oh, yeah.
Yeah, 100.
Yeah.
Raised, but
Now, some of them have not decided it because of standing and so forth, but I'm asking you, is there a court that has accepted?
Yes, very simple, Your Honor. Judge Maley's decision here. Does he address the statutes that I mentioned? Does he address Mattel? Does he address natural law and the law of nations? Does he address minor? He says that, I think he says minor is, he doesn't explain minor. He doesn't even discuss it.
No, he says the minor court left the issue open.
But then if I say issue, what issue?
Then he talks extensively about Wong Kim Moore.
Yeah, but
you seem to want to dismiss
no,
an extensive discussion in Wong Kim Moore.
Oh, no, I'll address
about the
Wong
English
Kim Moore.
common law and whether the English common law applied at the time of the Constitution was adopted.
Yes, I'll address that, Your Honor. But first of all, on minor, you said that they left the issue open. What issue? Not the issue of what a natural-born citizen is.
No, that's what he said.
Well, but that's
I will read it.
Yes, Your Honor. Look at minor, okay? The question is, what issue was left open? Not what a natural-born citizen is. The issue that was left open was whether the person is a citizen under the 14th Amendment. A citizen under the 14th Amendment. The 14th Amendment doesn't say natural-born citizen. If you go back to Article 2, it says the citizens of the United States are eligible, provided that they're citizens at the time of the adoption of the Constitution. Okay? So if you're going to show me you're a citizen, well, then you better have been born in 17 whatever. Okay? If you want to be a president today,
Doesn't it say in Wong Kim, reading now from Judge Akini, reading from the decision of Akini versus Governor of Indiana,
yes.
which is at 916 Northeast 2nd, 678, the decision of the Court of Appeals of Indiana. And it says, in referring to Wong Kim Park, the judge says, we affirm minor in that the meaning of the words, quote, citizen of the United States, unquote, and, quote, natural born citizen of the United States, unquote, must be interpreted in light of the, quote, must be interpreted in light of the common law, the principles and history of which were familiarly known to the framers of the Constitution. And then he goes on to quote extensively from Wong Kim Park, where they go into an extremely interesting and lengthy discussion about the English authorities and the English understanding of what it meant, and, quote, the same rules enforced in all of the English colonies upon this continent down to the time of the Declaration of Independence and in the United States afterwards, and continue to prevail under the Constitution as originally established. Doesn't that say that English common law, whatever that was, whatever the definitions under English common law were, that was what was adopted in the Constitution?
With all due respect to the United States Supreme Court and to Justice Gray, there's no support for what he says. And very simply,
he seems to think he's writing an awful lot of support in his decision.
But, he gave a lot of support for the wrong thing. He told us about states. The states. Yes, that's not a dispute. The states put it in their constitutions. The states put it in their statutes. But the national government did not put the English common law as defining citizenship. If it did, then why do we have the naturalization statutes that I just cited? That say, if you're born here, that's not sufficient. There's no jus soli. It's jus sanguinis. Why do we have the Venus case? Chief Justice Marshall telling us what a native or indigenous is. Why do we have English? I've cited these. Minor. Why does minor tell us that you have to have citizen parents if the English common law prevail to define citizenship? Wong Kim Park confirms minor. It cites minor and gives the definition of a natural born citizen. Wong Kim Park. But then it says, we're not dealing with a natural born citizen, we're dealing with a citizen.
All right, Councilman, I don't want to, I mean, if you have some more to say about the points of here, but I don't want to cut you, but it is starting to get on here, and I do have some work to do.
Yes, sir.
So and you've made your arguments in the brief as well. So is there anything more you want to specifically point out?
Yeah, one last thing is very, very important. St. George Tucker, and I've mentioned
St. George.
Yeah, now he's a fascinating individual, and what happens is St. George Tucker, he wrote it's called Commentaries on Blackstone. Why did he write it? He wrote it to show that the American common law was different from English common law. He took it from his lectures at the William & Mary law school, where they taught Littell and natural law and the law of nations. Very important. Justice Marshall was there. Wyatt was the professor. Jefferson, Tucker. These are the heavy intellectuals of our founding. But the point is that he writes that citizenship, okay, can be either acquired or inherited. Okay, it's acquired if you're naturalized. It's inherited. If you get it from your parents, only if you get it from your parents is it inherited. This is one of our founders. And then he says that the right to run for president is a civil right, which only belongs to citizens. But not a natural-born citizen. Not a naturalized citizen. Only the children of citizens have the right to run for president. He says it right in his. Only the children of citizens have the civil right to run for president. This is St. George Tucker in his commentaries, which completely obliterates Blackstone, because Blackstone said you're a natural-born subject if you're born in the dominions, under the obedience or under the allegiance of the king. That's not the law that we adopted. Again, it's clear as day. The statutes abrogated. The statutes that I cited abrogated the English common law on the national level. Okay?
Ms. Hill?
Okay. That's all very interesting and a good argument, but it's not evidence in this case. If we go back to some of the cases that Your Honor mentioned, for example, Ankeny versus Daniel says that based on the language of Article 2, Section 1, Clause 4, and the guidance provided by Wong Kim Ark, we conclude that persons born within the borders of the United States are natural-born citizens for Article 2, Section 1 purposes, regardless of the citizenship of their parents. Additionally, in the Milan case in Georgia, you
That's Judge Maloney's
Yes,
decision,
like a-
which is, now I have the decision, and that, for the record, was Farrar. There were several cases,
Yes.
but it's Farrar versus Obama, which is the lead case.
In that case, they rejected the challenge to Obama's eligibility to appear on the 2012 ballot, finding that Obama was born in the United States and is a natural-born citizen. Federal and state courts around the country have consistently recognized that a person born in the United States is a natural-born citizen, regardless of the citizenship of the person's parents, regardless of whether the person holds dual citizenship. For example, in Galvez versus Bridgestone Court, recognizing that children born in the United States to Mexican parents living in Mexico are nonetheless natural-born citizens. Another example is Perkins versus Elk. Is that the site?
Yeah,
Okay.
I think, yeah.
307 U.S. 325. A person born in the United States to naturalized Swedish parents was natural-born citizen even though she obtained Swedish citizenship under that country's laws. Another case, Yamaguchi versus Rogers, 181, F-Sup 934, 935 to 36, recognizes that a child born in the United States to Japanese nationals was a natural-born citizen.
Well,
More?
I mean,
It's time and time again. The bottom line is that the child born in the United States, the parents are United. And I wanted to also mention, in the Tisdale versus Obama case that was brought up by counsel, it was ultimately they dismissed the complaint challenging Obama's eligibility, finding that Obama is a natural-born citizen because he's born in Hawaii.
You know, those cases those were factual statements. That there was no analysis of what a natural-born citizen is in those
Factual statements. There's no-
I thought,
Go ahead, Mr. I think Mr. Olson.
For example, then also in Fat versus White, 253 U.S. 454, it reversed a lower court ruling against a person who claimed he was born in the United States to Chinese parents and holding it is better that my child's immigrants should be properly admitted than one natural-born citizen of the United States should be permanently excluded from the country. I could keep going with it. We've had
yeah. I just want to say very quickly, Your Honor, that those cases, there's no analysis what a natural-born citizen is. It's just assumed. It's assumed in the facts. In the facts. In other words,
Aren't
it's
those
like,
the holdings in those?
oh,
cases?
absolutely not, Your Honor. That's not the issue. The issue is not. They're just in the facts that the court says, oh, that this child born of Mexican parents is a natural-born citizen. It's, in other words, when they set out the facts. Okay. Yeah, that's not. The issue is not what a natural-born citizen is in the case. So it's like super dick, right?
Well, in a sense, what you're saying, I guess, counsel, is that because the natural-born citizen issue only is relevant to the president or candidates for president, right?
Yes.
Every other discussion about citizen is relevant to the more general population, shall we say. But, I understand that. But one of the elements that in the Wang Kim Ark case, and in the discussion, which is an extensive discussion of the English common law and its application to the United States and so forth, they continually reference not only the term citizen, but also the term natural-born subjects, natural-born citizen, so that, well, it may be true, and I think it is true, that in Wang Kim Ark, one could say that the issue of what natural-born citizen was not. If you want to vaguely say it was dicta, that discussion as it affects that term, I suppose one could perhaps say that because the issue there was not about a presidential candidate, but at the same time, the discussion in depth is about what those terms mean in the English common law, and also, again, to the extent that they conclude that, as I read the case, that they conclude that it was applicable in the United States under the Constitution. And they refer over and over, and the judge in Kennedy, which is the Indiana case, quotes only a portion of a very lengthy discussion, and they continue to refer to the meaning of natural-born, natural-born, which is the same language used in the Constitution, natural-born. And so, you know, obviously, we aren't talking about subjects in the United States, we're talking about citizens, but the, quote, natural born, natural, well, it's hyphen, natural hyphen born, is discussed quite a bit here. So, you know, we can debate whether or not the fact that they discussed it is somehow dicta, but nevertheless, I think that it's fair to say that the position that you are arguing, if you have more you want to say.
Yeah, one other point
before I go on.
Yeah, it's just, when you look at the Wild K. Bar case, Your Honor, in studying this, the key, one of the keys, okay, first of all, the whole discussion about English common law is only to make a citizen of the United States under the 14th Amendment. It's not to make a natural born citizen. Okay. But the case itself...
Well, I don't know if it's not to make a natural born citizen, because the issue in the case was not about the question of natural born citizen, but whether it defines what natural born citizen is, even though that wasn't necessary to decide for Mr. Ark, which arguably could make that discussion to that extent dictated. To say that the discussion isn't about what natural born citizen means, I'm not sure you can go that far, because they discuss it and use that phrase over and over and over in the discussion. So, yes, they didn't have to decide that for Mr. Ark.
Yeah,
correct.
One of the errors, one of them, there are many, one of the errors made is conflating what a citizen is, what a natural born citizen is. Article 2 tells us you can't do that. Marbury versus Madison said every clause in the Constitution has value. You can't just blend clauses together and assume they mean the same thing. If you're going to do that, then show us that they mean the same thing. But Article 2 says if you're a citizen, you can be president if you're born at the founding, okay, if you're a citizen. If you're born after the adoption of the Constitution, you've got to be a natural born citizen. Right. So the 14th Amendment says citizen. It does not say natural born citizen. So how can we just throw away the natural born citizen clause, conflate it, confound it, and just say, oh, well, that's what it means, and that's the
I'm not sure that that's what the court did in Wyoming, are they?
No, they did not do that.
They didn't do that. They said, here's what natural born citizen means.
Oh, they didn't say that. Absolutely not. And here's my further proof. Further proof is that the court says, referring to a paper of Philadelphia lawyer, Horace Binney. Yes. Okay, he wrote 3 papers. The second edition is what Justice Gray cited to. The second edition says in a footnote, a very famous footnote, says that a child born in the country to aliens is as much a citizen as a natural born child born in the country of citizen parents. It's right in there. So what does that tell you? Okay, that they're both citizens. They're both as much a citizen, but the other one is a natural born citizen.
All right. Anything else?
That's it.
All right. All right. Obviously, I have to issue a written decision in this matter. It is clear that the legal position that Mr. Apuzzo put forth with respect to the natural born citizen issue has been raised time and time again. And I reserve the right in my decision to explain in detail my finding, but there has been no court that has accepted the position in respect to Mr. Obama. There has been no court anywhere in this country that I'm aware of has cited that he has accepted the legal analysis that has been put forth by Mr. Apuzzo and the persons upon whom he is representing here with regard to the meaning of natural born for the purposes of the presidential qualification. And I've read Juan Kim Mark. It's an interesting decision. It appears to me that the court in that case attempted to define the meaning of those terms, even though one may argue that because Mr. Wong was not running for president, that natural born really wasn't crucial in regard to defining what he was. Citizen was, but maybe not natural born, but nevertheless, the discussion which goes on through the English authorities quite extensively, and then brings it into the context of the United States, discusses at length that phrase, natural hyphen born. And to say that they are not telling us what their understanding as the United States Supreme Court, what their understanding was of what that phrase meant, would be to really ignore what they wrote. And I don't think that that's something that any court has accepted. And I am not persuaded that the other courts have been wrong. So that I will take under advisement all of the positions. I will review the authorities and the cases. If something jumps off the paper at me that tells me that everybody's been wrong, including my preliminary analysis based on reading the brief was taken out of the reply brief, and reading the cases that I reviewed so far, I obviously will change my mind. I reserve that right. But on the natural born, I think you have a losing position. I will either affirm that in writing tomorrow, or later today, or I will tell you why I think I've changed my mind. With regard to the first issue, again, that issue has been defined by the parties in this case, and particularly by the petitioner, that the issue before Secretary of State is not the authenticity of the birth certificate put forth on the website and all of that. And that's why the issue with regard to the witness, the expert witness, and so forth was not relevant. The issue has been defined, and I will decide, is the question of whether or not there was some obligation on the part of Mr. Obama to establish to the Secretary of State his qualification to run for the presidency. The context in which this has been argued by the petitioners in this case goes to largely the issue of the lack of a birth certificate. I'm not sure, if the building had burned down, perhaps there would be some other document that they would say would be acceptable in place of the original birth certificate as a means of proving the qualification, which is the birth qualification. But there's been no suggestion that that's what happened here. So they basically seem to say that the obligation was to produce something to show that he was qualified, particularly something to show, because the only qualification that I gather has really been disputed here is the question of his birth, the place of his birth. Besides the natural born, because that only goes in if he was born here, the place of his birth. The date obviously might be affected by the place, but it's really the place of the birth. And that's the issue that's going to be decided here. We're not going to get into, and the evidence in this case for that reason has not gotten into, the other issue, which I know works all over the place in regard to this whole business, which is the authenticity of the birth certificate itself. That's not before me, it's not before the Secretary of State at this time, and it's not going to be decided in this case. Is there anything else that either of you wish to offer before we conclude the matter? Nothing else, Your Honor? Thank you. Appreciate your positions in this case. And I will say this, Ms. Hill, because I know in other cases, for whatever reasons, the respondent in those cases has chosen not to appear. And I appreciate, regardless of whether you win or lose this, I appreciate the fact that in this case, the respondent did decide that it was appropriate to have representation. So in some other cases, that has not been the case. And I think it's been helpful. I'm glad that that was the position that the campaign decided to take. I think it was the appropriate one. And I'm glad that they did participate, because I think that's important. So with that said, I will take the matter under advisement, and you will have my decision as quickly as it comes out. I do want to check, counsel. I do want to check through my office, because I don't speak to the Secretary of State's office at all, since it's a case before me. I do want to check whether they have a position with respect to releasing the decision to you, the oral communication, or whether they do not want it released until the actual written decision is filed. Because we do normally, the normal process is where everything else we do is written decision. And the normal process there is that once we have filed, we do it by email, once we have filed with the agency the emailed copy of the decision, we then release it to the attorneys. In this case, because, and this is, I say, it's not unique to the Obama case, but it's unique to election challenges, because we are requested to provide them with an oral, not the full decision, but an oral yes, no, before we get around to putting out the written one. I'm not sure if they have a position with regard to whether or not they feel it's appropriate to advise the parties of the oral before the written is filed. And I will discuss that, or have my staff, because again, I will have them determine, not only for this matter, but for all of the challenges. There were something like 14 or 16 challenges all over with regard to various candidates being heard all at the same time today. Whether they have a view on that, they have a position on that. Because again, it's unique to election matters.
I believe
So
on the Division of Elections website, it says that you would release the oral opinion.
it may. I haven't checked that.
Yeah, it's on the same page.
Is it on there?
Yes.
All right. Well, I'll confirm that. I mean, if that's what it says, that's
Yeah,
what
it's
I'll
just
do.
on the bottom after.
We sit here for the Secretary of State in this matter, and I don't want to jump to Secretary of State if that's not what the Secretary of State feels is the appropriate way. But if it's on the website, then certainly then we're going to be guided by that in terms of that. And if that's the case, then as soon as I am confident that that I'm satisfied with what the decision is, then you will be advised.
The court has both of our
Let me check and see what I've got here, because I may not have yours, since we didn't have your appearance until this morning, obviously. Let's see what I've got.
I can approach
I have, actually, I may not have you. Let me see. I don't know if I have anything on your letterhead. Let me see. It's going to be filed. Oh, I have, Mr. Apuzzo, I have yours. I've got your phone number and your email address. But I don't have this.
So that will be released to us then by email, phone, or how?
I think by both, actually. Again, I mean, it's going to be a yes, no. Because, as I'm putting the written one together, once I'm satisfied this is the answer, then I'm expected to advise the Secretary of State, and you will then be advised. If that's what the website is, then you'll both be advised. But that's just going to be basically a yes, no. You'll get the written decision as soon as it's issued. Don't know if it's going to be later today or if it's going to be by 10 o'clock tomorrow morning.
Yes, sir.
We have a lot of secretaries running around trying to do a lot of decisions for a lot of people today, all of which have to be filed by 10 o'clock tomorrow morning.
Wow.
We have a very unique system. Well, it's not unique. I don't know if it's unique. I noticed in Georgia that we're charging no time. New Jersey, especially because Good Friday was a holiday. One of the petitions we had, the objections we have been filed on Friday, we would have an extra day.
Yes.
But even that is tight. So it is what it is, and we'll deal with it. All right, thank you, counsel and parties, and that concludes this matter.
Thank you, Your Honor.
Thank you. The only people who don't want to disclose the truth are people with something to hide.